Welcome to our employment video about reaching an agreement with an employee to bring their employment to an end. I'm Mark Ridley, a partner in the employment department. Employers are often wary about proposing a severance package. They're concerned that if an agreement isn't reached, the conversation would be used against them in subsequent employment tribunal proceedings. It has long been the case that negotiations conducted with a view to settling an existing dispute would have the protection of the without prejudice rule. This meant that such negotiations were legally privileged and could not be disclosed in any subsequent employment tribunal proceedings. However, employers often don't want to wait for a dispute to have arisen before they start such negotiations. Indeed, if they wait for a dispute to arise, that could hinder the possibility of reaching an agreement. New law, introduced in July, changed the position. Employers and employees can now enter into confidential settlement discussions even where no dispute has arisen, and those discussions can't be referred to in any subsequent employment tribunal proceedings. The offer can be made either verbally or in writing. In our experience, it's best to do both. The offer can be made initially at a meeting, but the terms should be confirmed in writing to make sure that they are clear. The offer will outline what the employee will receive in return for signing a settlement agreement. The settlement agreement will provide that the employee waives any claims that they have against the employer, and in particular, employment tribunal claims. A payment in lieu of notice is not likely to be sufficient, as employees are entitled to receive notice as of right. An employee will usually expect to receive, in addition to notice, a severance payment as compensation for loss of their job. We are often asked what that severance payment should be. There's no set formula, but ACAS suggests the following factors should be taken into account: what the employment contract says regarding pay, notice and untaken holiday, the length of employment, the length of time it may take to resolve the problem if a settlement is not reached, how difficult it will be to fill the post, how long it might take the employee to find another job, the reasons for offering settlement, the possible liabilities and costs involved in dealing with any potential tribunal or court claim if settlement is not reached. There's no legal obligation to allow the employee to be accompanied at meetings to discuss the possible settlement. However, it's often good practice to allow the employee to be accompanied by either a colleague or a trade union official. If an agreement is reached, a settlement agreement is drawn up. This is a legally binding contract which brings the employment relationship to an end on agreed terms. It's necessary for the employee to obtain independent legal advice in relation to that agreement. It's standard for the employer to pay a contribution towards the employee's legal fees in respect of obtaining that advice. Under the law, employees have to be given a reasonable period of time to consider the settlement agreement. What is reasonable will depend on the circumstances. However, ACAS advised that this should be no less than 10 calendar days. It was anticipated that this would be a positive change, and indeed in our experience it's just that. Employers are feeling more confident making offers to employees, knowing that they shouldn't be referred to in any subsequent tribunal proceedings should an agreement not be reached. Prior to the change in the law, employers were concerned that the conversations would be used against them as evidence that the employee was no longer wanted and that any subsequent procedure was a sham. However, employers should not be lulled into a false sense of security. Such conversations will only be inadmissible insofar as they relate to ordinary unfair dismissal. The new law does not apply to claims of automatically unfair dismissal, such as whistleblowing, or claims of breach of contract. Most importantly, the new law does not apply to discrimination claims. Employers should be very cautious before starting a confidential settlement discussion with any employee who might claim that they've been discriminated against. Employers should also note that the conversation will not be inadmissible if they've engaged in any improper conduct. In particular, they must not put the employee under any undue pressure. Accordingly, whilst the change to the law is, in our opinion, positive, and whilst it will save significant management time so far as internal procedures are concerned, and give employers much needed peace of mind, advice should still be taken before an employer embarks upon a confidential settlement discussion. In particular, advice should be taken regarding the procedure for entering into a confidential settlement discussion to ensure that you follow the law and in doing so gain the protection of the new law. I'm Mark Ridley, Employment Partner at Hatton. Thank you for watching.